Yes, Ms Langdale.
May I call Claire Waxman, OBE, please?
Yes.
Please stand. Please repeat after me. I do solemnly, sincerely and truly, declare and affirm, that the evidence I shall give, shall be the truth, the whole truth, and nothing but the truth.
You are the Victims Commissioner for England and Wales since January 2026, and you have prepared a statement for the inquiry dated the 19th of May 2026. Can you confirm, subject to one small amendment that you require making at paragraph 56, where it should refer to the Victims and Courts Act rather than the Victims and Prisoners Act? Subject to that amendment, the statement's true and accurate as far as you're concerned.
Yes, that's correct.
Can you tell us something, please, about your role as Victims Commissioner and how you discharge the role?
So as Victims Commissioner, I am responsible for championing the voices and interests of victims and survivors and witnesses. You need to extract those issues and take that to government and to criminal justice agencies as well, to encourage good practice across those criminal justice agencies and to review the Victims Code. That role has been strengthened in subsequent legislations, in the Victims and Prisoners Act, being able to monitor that Victims Code. That's very much reliant on criminal justice agencies sharing data with me so that I can monitor their code compliance. And then it's being strengthened even further through the Victims and Courts Act. There'll be a duty on me to provide a report on code compliance.
Can we have page 3 of your statement on screen? So that's 455001, page 3. And do you set out, in so far as relevant to this inquiry, that you've published, or your office has published, multiple reports examining bereaved families' experiences following homicide, availability and impact of advocacy services, and the position of victims in cases involving mentally disordered offenders? We're going to come to specific guidance later, but firstly, these communication issues. Generically, what have you identified in respect of the police?
So communication issues come up again and again for victims and families navigating our criminal justice system. It doesn't just start and stop with the police, it goes through the entire criminal justice process. But in relation to the police, what does come up is real difficulties in accessing information around the investigation, getting regular updates, getting information sort of all at once and then nothing for months. Under the Victims Code, they should be regularly updating victims through the process on the investigation. But that information is often not forthcoming. Victims and families have to really push agencies to deliver the information that they need and deliver it in a way that actually they understand. And that's really important because often it's seen as a tick box exercise. So the police will say, well, we did give the victim the information, but the victim hasn't quite understood what that information is. So it's really important that the information given is done in a timely way, a sensitive way, and a trauma-informed way.
And is individual specific?
Absolutely, yeah.
And sometimes reasonable adjustments are required?
Absolutely, depending on the needs of those victims, and that's really important to do proper and robust needs assessments of victims and families who are going through the criminal justice system. Again, that's a right under the Victims Code, but it is not being delivered consistently and certainly not being delivered well.
And certainly in terms of bereaved families, it should go without saying the trauma that's involved in that and the special care that's required.
I mean, it's certainly a very different case with bereaved families. I have met many bereaved families over the years, and the family liaison officer will say, well, I've shared the information of what to expect through the criminal justice system. And families will say, well, I don't recall being given that information, or I don't understand that information. And often it's given very early on in the process where a family is dealing with the shock and trauma and grief of what's happened. and then they're beginning so much information to absorb, often written through a booklet, or even they're told verbally, and we really have to change the way that we give that information to families. You know, there is a neurobiological impact of trauma on memory and recall, something that the criminal justice system is starting to understand and starting to train and reflect in their practices, but it hasn't gone far enough. We need to provide information in, you know, a way that families going through trauma and grief can process it.
And comprehend.
And comprehend.
Plain language.
Absolutely. Plain, simple language, done in a way that they fully understand and to check they understand. And at the right time as well. And I think that's really important. You know, I've come across families who've been forced to sign, you know, things in relation to the Human Tissue Act at a time where they've just lost a loved one and they don't recall signing it, and it's only months down the line do they know what they've actually signed. You know, we can't be putting that on victims at times when they are really trying to process the shock and the grief and the trauma that they're going through.
You set out here generic themes for the Crown Prosecution Service as well. Can you enlarge on those for us, please?
Yeah, so as I've talked about, there is an ongoing theme here. The victims and families will report in the criminal justice system. As I talked about, it's the lack of communication and that lack of information. And that sort of follows throughout, and that's a theme within the Crown Prosecution Service. Many victims and families will say that they find the CPS a faceless organisation. Often the information is being given to them via the police or a family liaison officer. And I would say very difficult information, sometimes, you know, legal information, the reliance on that family liaison officer or the officer, police officer, to share that with a victim or bereaved family member. I think it's much more important that the CPS take an active role in that. Especially around where there are issues around charging decisions, if there are plea bargainings and plea discussions, families and victims really need to understand that process and what's happening and why.
And how do you see the role of an independent prosecutor such as the CPS and victims, and what their communications need to be with victims?
So the CPS have a bereaved family scheme, and within that scheme they are meant to meet bereaved families at critical points of the process to explain it. What I'm told by families is that's quite inconsistent, that service. It's not always delivered. And if it isn't delivered well, they don't feel that they get the meetings at the right time or they're getting the right information and explanation.
And do you have any sense who they are meeting?
So they will often meet with the prosecutor.
The council, prosecution council, or the CPS
so
lawyers,
it depends,
or combination?
It's a combination. And I think that's an issue as well, because often that they're not meeting the same person, because it might be someone different when they get to court, obviously. So it's about understanding who they're meeting and what the information is that they're going to get. And I think a lot of the time families can feel quite dissatisfied with those meetings. It's a sort of a one-way where information is being given to them and they don't feel they really have much voice and representation in those meetings to challenge some of the decisions.
Mm-hmm. If we just have your statement off for a moment, and RLIT 5057, page 1, the German code. You say families sometimes feel at the outset, if you like, and that they can't challenge decisions. Is that fair?
Yes.
We see here in the German system, page 1, whoever is aggrieved by an unlawful act, and if you can go over to the page, 2, may join a public prosecution or an application in prevention of detention proceedings as private accessory prosecutor. So some countries clearly are considering victims having a right to play a more active role, aren't they? And if we look at the guidance, RLIT 0000, this is a guide for victims prepared by the German Federal Ministry of Justice. It's page 4 and 5, please. So the document's RLIT 5059, please. We can have 4 and 5 alongside each other. We see in the preface, for far too long, German criminal proceedings law focused only on offenders. Victims were primarily evidence for solving the crime and no more than that. Fortunately, that is a thing of the past. And we see on the second page at the top, in Germany, we've not only implemented the European requirements, have gone far beyond them. Our provisions on psychosocial support services are a milestone for children and young people who've become victims of serious violent and sexual offences. They now have a legal right to free professional support services throughout the entire proceedings. The court may also assign psychosocial support services to adults in certain cases. And then if we can go, please, to page 22. We see legal counsel if you become the victim of a crime, required to give evidence. We see further down, in special cases, you may even be provided with a lawyer at public expense for the duration of the hearing. If we can go to page 44, please. Private accessory prosecutions. This also, we see at the bottom right, applies to other offences such as stalking or violation of court orders in cases of domestic violence. As the victim of any other offence, you're also authorised to join a prosecution as a private accessory prosecutor if this appears to be necessary for special reasons to safeguard your interests, particularly if you're suffering from the serious effects of the crime. You are also entitled to be a private accessory prosecutor if a crime has resulted in the death of a close relative. And then if we look at page 46, removing the burden on victims or bereaved families in those circumstances, we see, to avoid misunderstandings, if you wish to become a private accessory prosecutor, you are not required to submit your own bill of indictment. That remains the job of the public prosecutor. As a private accessory prosecutor, you do not even have to be present in court yourself, nor do you have to make applications, but you are allowed to do so, just as you're allowed to submit your own statements as a private accessory prosecutor. Private accessory prosecutors are always notified of the court's decisions, and you'll receive a copy of the judgment. And we see there's also some appellate remedies offered. Have you ever considered whether victims' rights to support and information should go further than that in the context of the criminal justice system?
Absolutely. I mean, the big issue that victims and families in this country face is they are very much treated as bystanders in our criminal justice system, and that is the ongoing issue for them that comes up time and time again. Much has been done to try and strengthen their rights through various legislations over the years and through the Victims' Code. But I'm afraid to say it very much sits on paper and it doesn't really translate into a meaningful change on the ground for so many victims and families. And so we hear the same issues come up again and again. The very basics aren't being provided consistently and well around information, communication, even knowing about the Victims' Code, even knowing about referral and access to support services. I would call that the very basics we're not delivering. But the big issue for so many victims, and especially for bereaved families, is that lack of voice and representation throughout the process. Some years ago, I very much pushed and championed the need for legal independent support in rape cases. And we have made progress on that. And the government has funded, I think, 6 million, if I believe, into legal independent representation for rape victims. Now, that's not to come into court, like the German model, but that's the start of something a little bit different. That's when third-party material is being requested from the rape survivors. They can request independent legal support that can advise them through that process, which is really critical for them in relation to their rights to privacy through the process.
So through the advocacy support, they can get legal support, independent legal support as well?
So it's not through, it'll be separate. It'll be legal independent support will now be given to rape victims. Well, firstly, they've got to know about it and then obviously be able to access it to help them understand the information that they might be being requested of them. So the third-party material, be it medical records, therapy records, social services records, even phone records. There is that sort of check and balance of a legal independent support advising them whether they should be agreeing to have that disclosed as part of the court proceedings. So there's been some progress, but I would very much welcome us moving even further. I think we have a real challenge in our criminal justice system. Part of the problem is the whole system is structured around the rights of the defendant and the rights of an offender. And the role that I have always tried to play over the years is about how do we balance that system and look at parity of rights, because I believe victims and families should have equal rights and equal status in the criminal justice process. I mean, the German model is an interesting one. Obviously, their system is different, and I haven't looked at it in great detail. I work quite closely with my equivalent in Germany, so have spoken to him about the differences. It is obviously more inquisitorial, and obviously there's some adversarial elements to their justice process. But I believe from conversations only with my counterpart in Germany, the Victims Commissioner, Roland Weber, he says it works very well for bereaved families, and there's quite a huge uptake of them coming in and participating because it gives them much more transparency and openness around what's actually happening. They can put questions through their own victim, the counsel and representation.
And that's an expectation under the code or the practice guide, that they can do that. It's not a thorn in the side, it's a right and an entitlement.
It's a right and entitlement, and it's very well understood and accepted as part of their criminal justice system. It would be something I would very much welcome and support, our system going in a similar way, but of course I appreciate there might be some pushback. There often is when we want to try and reform our criminal justice system to become much more victim-centric.
Can we have your statement, page 4, please? So 0455001. You touched upon the role of family liaison officers earlier, and you set out here their role at paragraph 16. And you also set out potentially the various conflicting elements of their role. Would you like to expand upon that, please? What they're required to do, and given that they're from within the police, where that might create tension?
So family liaison officers are designed to be that sort of that single point of contact for those families. However, they are part of policing, so they're not independent. They're part of an investigation team. They're to provide, obviously, the updates on developments through the investigation and to gather that information from families and to sort of guide families through the process as well, and, of course, signpost them to support. But I think there is a real misunderstanding still about their role, and the issue that I see is that we see differentiation between flows. So I think much more needs to be done to really clarify their role and remit. I see some flows go above and beyond what they are meant to be doing because they know that the families need more, but that's not necessarily their role. And families become quite frustrated because of that lack of independence, because they're still part of police in the investigation. And families often want that independent advocate that is really working on behalf of the family to push forward their needs and their requirements. So I think there's a bit of rub and tension with that role. I do pick up issues quite often with family liaison officers. Often there's delays in allocating them. We've heard about poor performance from some FLOs. Some, as I said, go above and beyond, but some just don't seem to have been trained well enough to deal with a grieving family. Some of the language we've picked up isn't very sensitive or trauma-informed and actually has caused more upset to families. There's their availability. Sometimes we hear of flows starting and then being taken off and different flows being appointed to a family, and that's very disruptive. You need that continuity. I think that's so important.
When you say trauma-informed, would you like to just explain what you mean by that?
Yeah, of course. So it's about understanding that you are, like I said earlier, you're dealing with people who are processing grief and trauma. And so there is lots of evidence to demonstrate, to show why families can't take in information and can misunderstand information through no fault of their own. It is because they are processing their grief and trauma, and that impacts their memory and recall. So it's really important that when people are communicating and a family liaison officer is communicating, they understand that, they understand the needs of the family, and they communicate in a way that is clear, that is sensitive, and that is, when I say trauma-informed, it's understanding what they are going through, what they are trying to process. It's putting compassion and empathy into it.
If we have, please, page 5, you set out in principle how flows can best perform their duties. Again, can you expand on that, please?
Yeah, so again, it's just talking about that timely, sensitive, and proactive and regular communication. Really, really important for families. They need that. They need that for reassurance. They need to know that things are happening and moving. Clear explanations. Where are we in the process? Why isn't something happening? Just constantly updating them when it is necessary in a way that they can understand and process. And as I said, maintaining that continuity of contact. We have had cases where I've met with families where flows have been taken off after a few months due to allocation issues, and other flows have been assigned. And I think that's terrible practice, because it's really important the flow builds a rapport with the family. Equally, some families will comment that they haven't built a rapport with that flow, and they want the flow changed, and we need to understand that and listen to the needs of the families. If they say, actually, this flow isn't right for our family, we want somebody else, that we respond quickly and resolve that.
Page 6, please, paragraph 24. You set out the dual role can create challenges, for instance, when information cannot be shared due to evidential or legal constraints, where communication is shaped by investigative considerations, or where families expect the flow to advocate on their behalf in ways that fall outside their policing role. You say it would be of benefit to define the role, and you can have, please, page 7 on the screen as well. How would you see it better defined?
So I think it needs to set out the parameters a lot clearer. And I think it does. There is a leaflet that is given to families, but I think it's to explain it as well to families that there will be information, whilst they're there to keep them updated, there could well be information that they are unable to share due to the investigation. So it's just making sure families, because often I hear from families, and that becomes quite an issue for them. Why aren't we being told? Why are we being kept in the dark? So to explain.
And they're rarely witnesses, are they, of bereaved families? They won't have been there, particularly in the cohort we're looking at. So if they're not witnesses, is that even more difficult to understand why information can't be shared?
Absolutely, because they're not going to be going into court to give evidence. They're a bereaved family, and often there's this issue of why can't we be told? And again, that's for the role to be better defined and explained, and whether we are, whether there is still information that can be shared with families. Do we need to push it a little bit further? Often there is this reticent and sort of defensive position that families will complain to me about.
The inquiry has been looking at the requirement or need for independent support alongside flows. What's your evidence around that? Do you think that would be beneficial for those affected by homicide?
Yeah, so this is where, the criminal justice system for victims and families is so difficult to navigate. I think it's difficult for all of us. It's so fragmented. We don't have one system. Although it's a criminal justice system, every agency works in silo. And we expect victims and we expect bereaved families to navigate that very complex system. And whilst with bereaved families we do have the flow role there to help them to try and navigate, I believe there are a number of flows who also aren't familiar with all the different parts of our criminal justice system, so aren't necessarily well equipped or well trained to support families through that process. So for me, it's about the role of advocates. And we do have advocates for other crime types. We have it for domestic abuse. We have it for rape and sexual violence. We have it sometimes for stalking. My predecessor, the late Baroness Newlove, did a report on it, going above and beyond, and it talked about that patchwork provision around advocates for different cohorts of victims. And again, there are different types of advocates. So for me, the big vision and ambition that I really want for victims and families is that we create something, and I've talked about this in my recommendations, around which I've called a victim care hub, but it's that single point of contact when victims and families are entering that criminal justice system. And that single point of contact would be responsible for victims and families only. So they're not part of policing, they're not part of the Crown Prosecution Service or a VLO in probation. They are there to ensure that the rights and entitlements under the Victims Code are delivered to victims and families at the right time and are delivered well, that they are able to get all the information and support that they need to navigate that justice process. That's not to replicate what we have in advocates, because we do have some advocates who will be coming into the system to support victims in court. But many of the advocates I talk to, IDVAs, so the Independent Domestic Violence Advisors, or ISVAs, they also struggle to get the information from the criminal justice system to give to their victims that they're supporting. So for me, it's about looking at a different way in which, when victims are coming into the justice process, we have something that is front-facing, that deals with victims, and the whole wiring of our criminal justice system sits behind this hub or centre, whatever it is, to help them through it. And if they need extra advocacy, because we have some wonderful advocates, so in domestic abuse, they're looking at how do we keep that victim safe, so they'll be looking at support services around housing, even around health, making sure there's safe accommodation, needs around children. So it goes much wider than the criminal justice system. So there is, at the moment, it's a mess. It's so fragmented, and that is the big problem for victims and families. We've got different parts of the criminal justice system trying to deliver little bits of the process, but there's no end-to-end service that's really gripping the journey for victims and families.
For bereaved families in the circumstances we're examining here, their engagement after these horrific events won't just be with the criminal justice system. We've seen it's with the NHS, it's with other services and communications. And it's clear from their evidence that they've benefited a lot from the help of their solicitor, knowing where, how, who to address the issues they were concerned about, such as unauthorised access, things that go outside the criminal justice system and advocacy targeted just to the criminal justice system. Do you think that suggests that there is wisdom in a category of cases such as homicides for solicitor support to signpost, to direct, so that messages aren't lost, key messages, and when you need to approach some organisations like the NHS with some knowledge about how you might do that?
There's an absolute need, because there's a gap here in support. So we've talked about, obviously, there's an issue with the criminal justice system. It doesn't function well enough for the needs of victims and certainly for the needs of bereaved families. But what you're talking about is wider, because of course their journey goes much wider than the criminal justice system. Who is going to provide them advocacy? So as I said, similar to for domestic abuse, there are advocates who are providing the domestic abuse victim with support, not legal support, but support around navigating issues with housing, maybe family court, issues around child contact examples. So there is obviously a gap in provision for families here, whether that is advocates or legal advocates or some legal representation, I think should absolutely be explored. Because I don't think the onus should be on families going through the worst things imaginable, dealing with grief and trauma, to try and navigate, one, our criminal justice system, and then all the other areas as well without proper support.
That can come off the screen, please. And can we have WITN 02580001, pages 32 and 33. And this is an extract from Mr. Hendy's statement and reference to mental health tribunals. Can we have a look at it, please? Page 32 and page 33, please. Mr. Hendy says from paragraph 179, in my experience, unlike the parole board, mental health tribunals have been extremely reluctant to disclose any information to victims, despite having wide discretionary powers. I was shocked to learn victims are not considered to be interested parties in a legal process about the release of their loved ones' killers. Affected families are not allowed to appeal any tribunal decision as they are not interested parties. The decision to release previously dangerous patients are matters of serious public and not strictly private concern. Victims currently are only allowed to make submissions on conditions of discharge and on no other matter. Many find this patronising and offensive. I understand the tribunal judiciary actively fought the introduction of victim impact statements to tribunals tribunals under the Victims and Prisoners Bill and was successful in limiting them to just terms and conditions. Tribunals do not seem to have any understanding or received any training in the needs of victims. Do you agree that mental health tribunals lack openness and transparency with regards to victims of serious violence previously perpetrated by patients?
Yes. So it's come up again and again. I've worked with Julian, I think over 15 years now, so I'm fully aware of the issues of what he's gone through and all the families that he's supported over the years with mental health tribunals. My predecessor also did a report back in 2018, interviewing, I think, 9 bereaved families, and so it obviously brought to light a lot of the issues that Julian is talking about here. And we've tried to make some legislative change. So recognising that the mental health tribunals were very closed, there's a lack of transparency and openness, and that compounds the harm and trauma for families. A big issue is just, why can't we have that information? And of course, the response is always around patient confidentiality. And what we tried to push, I did some recent amendments to the Victims and Courts Bill, was to try and put into place something that made the tribunals actually think about, yes, patient confidentiality, but we have to balance it with victim safety, public safety and victim well-being. Unfortunately, we were not successful. Government rejected those amendments. There has been some commitment by government to address some of that through potential guidance and training, but I don't believe it will go far enough. And I think this is still an area where we need to see more openness and transparency for victims and families, and not always, falling on the position of, due to patient confidentiality, we cannot share it.
I mean, they're clearly interested parties at a human level, aren't
absolutely they? They are. And I think, it's about, recognising the actual harm being done to the families when you deny that information, because it does compound harm and trauma, and prevents any ability for them to, families are never going to sadly really cope and recover, but you want them to find some peace and to not be involved in all these processes for years on end. And I feel very sad for them that they cannot get the information that I think they deserve for their own well-being and for their own safety and for public safety as well. So I think this is an area governments still need to address. We have made some progress. So we have got now victim impact statements, victim personal statements in mental health tribunals that came in under the Victims and Prisoners Act. I completely agree with Mr. Hendy's evidence here. There is a reluctance still with tribunals understanding the role of the victim impact statement and why it's so necessary for families to have that submitted and to read it out as well. From my understanding, from what Mr. Hendy has shared with me over the many months, is that actually I think most families are being rejected when asked to read their victim personal statement out. So there's certainly a lack of understanding from the mental health tribunal perspective of the role of the victim and family and why these things are so needed.
And as you say, Baroness Newlove prepared a report on entitlements and experiences of victims of mentally disordered offenders. If we can have, please, WITN 0455005. Page 2, please. We see paragraph 3. Mentally disordered offenders do not have the same entitlements under the Victim Code, neither do they receive the same level of support and assistance. This seeming inequality in treatment prompted me to investigate this further to assess the impact this had on the victims and concerned. She said, I'm also indebted to 100 Families, a charity which supports victims of homicide committed by mentally disordered offenders. It has hugely assisted us by sharing the experience of its membership and enabling us to contact victims. The general message I take is they feel isolated and unsupported in a system that can appear to pay little regard to their needs or support. Victims of mentally disordered offenders are not entitled to submit a victim personal statement when the offender's case is reviewed. Neither do they have an entitlement to attend the hearing and present their statement in person. And if we can have a look, please, at WITN 0455006, page 1. setting out, as you have helpfully done already, at paragraph 4, hospital managers must provide information only when they decide it's appropriate to do so. This risks further embedding a culture where an offender's patient's privacy is prioritised over the needs of victims. Managers are not required to give reasons for their decisions to withhold information, nor are victims able to challenge their decisions. The bill's an opportunity to address this procedural unfairness. And we see the proposal as ensuring hospital managers take a balanced approach when deciding whether to disclose information on offenders by placing a statutory requirement on them to consider the safety and well-being of victims. And when a hospital manager has decided not to disclose part or all of the information requested, placing a requirement on them to provide written reasons to the victim for that decision. So you would still agree that that would be positive steps forward?
Yes, I mean, those were the amendments that I put forward and supported and pushed for, so I was very disappointed when government rejected them. Understood.
Can we have a look, please, at going above and beyond, mapping the provision and impact of victim advocacy in the criminal justice system, in key 28, page 1. March 2024, would you like to tell us what this is about? I'm going to take you to specific parts.
Yes, so I mean, again, this was done by my predecessor,
yes.
So before my time in this role, and it was to look at, as I said, sort of this patchwork provision of advocates for different victims. So looking at, talking to different PCCs, understanding how they commission the service, and also looking at advocates and talking to them about what they provide and what they can't provide and some of the issues that they face when trying to support victims, and then obviously talking to victims themselves.
And we see from page 4, the report made recommendations to improve the impact and provision of victim advocates, to improve recognition of and support available for victims advocates, to ensure support available to all victims, whether they choose to report their crime or not, to ensure long-term sustainable funding, providing a range of advocacy services, and to ensure that all groups of victims have the opportunity to access support from a service of their choosing. And we see at page 6, again, something you reflected earlier in your evidence. At the bottom, the most significant finding from our research is that advocates help to keep victims engaged with the criminal justice system. And it's key, that, isn't it?
Absolutely. So it wasn't in this role. When I was in the London Victims Commissioner role, one of my final reports was around victim attrition. So that's when victims report and choose to withdraw. Well, I say choose, they withdraw from the process. Big part of that evidence, and it's reflected here in this evidence as well, this research, is that victims can stay better engaged in the process and won't withdraw if they have an advocate. So they have someone that is helping them navigate that process, meeting their needs, making sure they're getting the right support, the right information throughout the process makes a massive difference to their journey and their ability to cope and recover afterwards as well.
And we see at the top of page 7, inconsistency in the advocacy funding and commissioning landscape. That's not without complication, is it?
No, so this is very challenging because there is obviously PCCs will fund advocates, but we will also see local authorities in relation to IDVAs. So it is a very confusing and fragmented landscape around funding as well. And so we will see some areas funding more for certain victims and obviously less for other victims. So it is really a bit of a postcode lottery as to what victims will be able to access.
And we see page 37, halfway down the page. Our findings suggested that there was a recurring need for advocacy roles to be better defined, as different advocacy roles appear to be offering different types of support depending on their specialism, area or organisation. An agreed definition would help build a specific service specification and help with joint commissioning. One respondent from an office of a PCC highlighted the confusion around the definitions. And page 45, please. Reference to multiple gaps in current advocacy provision resulting in insufficient support for certain victim groups. Would you include this group within that?
Yes. I think there's a misconception that because bereaved families have family liaison officers, somehow that advocacy role isn't needed. And as I said, that's why we need to look at defining these roles much better. And I would say the same here as well for advocacy roles. As I say, I meet different IDVAs and ISVAs, and some are really good at understanding, for example, the criminal justice journey, or some specialise more in sort of health and housing on behalf of victims. So there's a lot of disparity between the roles. So I think we need, this is one of the big focus areas for me coming into this role as Victims Commissioner. I've been saying to government already, I want us to look at what support provision is already provided within our criminal justice system and by which agencies. I want us to properly map that and then look at all the different advocates as well and who comes into contact with victims. Because I think there is duplication in areas and there are gaps. And nobody has got a proper grip of that victim and family end-to-end journey. And as you've rightly said, it's not just the criminal justice journey. Families are going to go on and have parallel journeys as well, and we need to understand that from a victim and family perspective if we hope to better provide support and services to them.
Page 48 and 49, please, recommendations. And we see on 49 recommendations for victim hubs. Can you expand upon what you see the victim care hubs to be? And as I understand it, they're not intended to replace existing roles, are they? It's to
no,
come together.
And that's where I've just spoken about. There's a real need to map out what's the current provision and have a look at everything, because many victims I speak to, and even if they do have an IDVA or ISVA, or if they don't, coming into the criminal justice system, they're very much reliant on those agencies, criminal justice agencies, providing them with their rights. And they're not fully aware of their rights. They don't know what they should be getting at which point of the process. And why should they? You know, why do we want to put that onto victims and to families? So the idea of the hub is to have this entity, this organisation, that is very much, it's independent, but it's part of the criminal justice system. So it has to be able to access police systems, CPS systems, etc., to be able to give the information to victims and families when they're reported and when it's going through the justice process. So it's not to provide necessarily what advocates do, but it's just to make sure it's almost like a justice navigator. Someone is responsible for helping victims make sure, for example, their victim personal statements are done properly and on time, and they understand what the victim impact statements are about. Big issue that comes up, being told too late in the process about updating their victim impact statement, not being advised on what it can actually go into a statement. I have met bereaved families where they've received victim impact statements with red lines through it from the CPS. That's incredibly upsetting and distressing for families. They don't understand, why have you removed what I've put into a statement? So again, having this sort of justice navigator or hub model would support and advise victims and families of what their rights are and what they could put into a victim statement, making sure special measures, they understand what special measures they can have when if they're giving evidence in court, and to make sure that it's absolutely happening. And also a troubleshooting mechanism. What often happens to the victims that I meet and families is there are delays in communication and investigation or getting to court. There are issues that arise along the way. There is nobody there for them to communicate to and say, please troubleshoot this, deal with this issue so the case can keep moving along. And that's a big issue for families. So again, it would have this sort of troubleshooting mechanism where the hub could say, maybe it's to the officer, you know, you've not given the update to this victim and they're about to withdraw if you don't explain what's happening with the investigation. I have seen this model work in other countries. When I was the London Victims Commissioner, I went to Quebec because there's quite a lot of good practice in Quebec, and they have this sort of single point of contact hub for victims. It's called CAVAC, and it sits alongside police and CPS and the courts, but again, it's that front-facing agency or hub that deals with that victim, so they understand the needs of that victim. They can make sure then the police and the CPS and the courts are delivering a service and a response to meet the needs of those victims.
Is there a danger they get repeat or worse, inconsistent messages? For example, around a victim impact statement, the flow would presumably, if it's working alongside flows, have a view about when that had to be provided, and someone in the hub having a different view or understanding of dates of provision. How do you stop that?
So for that, and it's a very good question, and that's why there needs to be, I mean, this hasn't been mapped out in any way. This is just an idea and something I've been trying to drive forward for some years because I can see the gap in support in the criminal justice system. But I don't want it to duplicate. It's about appointing that single point of contact. So, for example, with the bereaved family, if you have a flow appointed, then it is the hub and the flow that will more likely communicate, unless that family wants to come in directly and speak to, let's say, the hub. Because it should be the flow responsible for telling that family about the victim impact statements, when they need to be done, what should be going into it, etc. So we don't want to, as I say, don't want to duplicate, but there are gaps. So we want to make sure that there is something for victims and families who are navigating the justice process. And it could be the flow is the person that actually delivers that. And if it is going to be the flow, then we need to ensure there's good guidance and trainings for flows, because as I've talked about, there's inconsistency in their understanding and the information they sometimes give to families that isn't quite correct about the criminal justice system, especially around legal outcomes. It's not always explained clearly.
Thank you. That can come down, please. And can we have instead WITN 0455002, pages 5 and 6. This is a summary of victims' rights. They'll be very well known to you, obviously, but can you tell us what these are and why they are important? Page 5 and 6, please.
Yeah, so
We
so
have
there are
both
12
together.
Okay, so there are 12 overarching rights for victims. I would say this is the minimum level of service victims and families should be receiving. And it's about making sure that the right to be able to be understood. So we've got to make sure that all the needs are understood about victims, making sure the investigation, they're getting updates throughout, getting information once they report the crime and go through the process. They need to be told about their rights, they need to be referred, told about support services, to be told about compensation. So they're very basic rights, information about what to expect if you're actually going into court, giving evidence, have a pre-court familiarisation visit, making sure they know about how, when they're going to give evidence, who's going to be there, making sure they do their victim impact statement. So these are what I would say are your sort of basic rights that should be delivered. The big issue on this is that, and I have just done a response to the government's victim code consultation, and it's a hefty response, 70 pages, but I did a huge amount of engagement with agencies that support victims, but victims themselves. And what frustrates me is that even in this role, so I am meant to do a report on code compliance, I'm meant to oversee and monitor agencies' compliance with delivering the code. Mm-hmm. There is no way for me to fulfill that part of my duties, because there is no framework still to collate the data from all the different agencies in relation to how are you delivering these code rights to victims. That doesn't exist still. And we know on the ground this still sits very much on paper, it's not being delivered in practice. So the amount of victims that I speak to who are not receiving their basic code rights comes up again and again. And then where's the accountability?
Are they even aware of the code in a number of cases?
No. So, the figure's gone out of my head, forgive me, but in the victim survey that the last Victims Commissioner did in 2024, I'm trying to recall, I think it was, I may get this wrong, I've got all the numbers in my head, I think it's around only a fifth knew about the Victims Code. So I think it was only, am I right? I think only 17%. Again, we might need to just fact check that.
We will.
It's a
we'll
figure.
go to it next.
But it's a very low number are still told about their rights. And that's a very basic, because they should be told, because it helps to empower them and gives them some support to know, okay, I know what I'm entitled to. Many victims I speak to, though, say, and it's a very strong point, I don't know if I want to know when I've come into, I'm a victim and I've come into the process. I don't think it's something I can start taking on board as well. It's a lot of information to know what I need and when I need it. That's why that role of that victim care hub would be so critical around the delivery of these rights, because we put a lot on victims to then, you've got to know about your rights, and then there's an onus and responsibility on them to almost advocate for themselves and push the agencies to deliver those rights. I think we ask too much of victims. And I think we should be doing much more around, awareness in the public and in schools, training to understand what are your rights if you become a victim of crime.
And the police and CPS.
Yeah, I mean, absolutely. They should be training. Unfortunately, it was not something I got into the Victims and Prisoners Act. I wanted mandatory training for all agencies on the Victims Code, but the government rejected that into the legislation. There is only a duty on agencies to promote the code. None of these things that have come into the Victims and Prisoners Act about better monitoring of compliance with the code and my powers within the code have actually come into effect still. So, again, it's legislation that hasn't been implemented.
In terms of victims' rights, there's also enhanced rights, isn't there?
Yes.
The code acknowledging those who are victims of the most serious crime, including bereaved close relatives. And what can people expect under the enhanced rights?
So when you're vulnerable and under the enhanced rights, you should be getting communication and information quicker, within a day. And obviously then that's when we look at if they're going into court, that's around special measures as well for enhanced vulnerable victims.
The 3 surviving victims of the Nottingham attacks were allocated one flow between them. And when the CPS opened in this inquiry in 2026, they had wrongly believed that they were allocated 2. One of the surviving victims, Wayne Burkett, has endured a brain injury which inevitably requires adjustment in communication. Another, Sharon Miller, was unable to leave her house at the time of the sentencing hearing, and you will recognise this from other victims' experiences, didn't want to see the face of the defendant or pictures of the defendant. Both of those victims, where the defendant had pleaded guilty to attempted murders, should have had the utmost care and attention in explaining to them what was happening and adjustments made in doing so. Would you agree?
Absolutely.
In terms of Sharon Miller, she wasn't told, for example, you could join a hearing via Teams or a CVP link. And of course, you can have an audio link, can't you, only if you don't want to see people's faces in the courtroom. None of this was explained to her as an option or a possibility. And for Wayne Burkett, no real effort taken to keep him apace with what was happening. Participation in proceedings, it's not enough, is it? It's nowhere near enough what's happened there.
No, but this is their basic rights not being delivered. And again, the frustration with this victims code that comes back to me time and time again from speaking to victims is it feels quite meaningless, this code, because if rights are not delivered, and they were not delivered in these cases, what's the accountability? Who do we hold to account for failing to deliver basic victims' rights to victims in this country? Nothing. And that, I have to say, is an outstanding frustration of mine as Victims Commissioner. I started campaigning before I was ever London Victims Commissioner and Victims Commissioner on a victims law to strengthen victims' rights in this country. I had a vision that that victims law would deliver that. And what we got in the Victims and Prisoners Act, unfortunately, watered down the most important part, which was to give victims' rights teeth and accountability. And that has not happened. And so therefore, when victims don't get their rights, they get an empty apology letter maybe from the agency, the police or the CPS or whoever failed to deliver their rights. They could go to the Ombudsman for breach of victims code. We used to have quite a long, convoluted process where the victim would have to go to their MP, and talk about the code breach, and then it would be referred to the Ombudsman. So I ensured we removed that MP filter to make it easier. But I had a victim only recently who I encouraged to take it to the Ombudsman because the police had failed on her code rights. But because the police had given an apology to her, there was nothing more to be done. And so it lacks teeth, it lacks accountability. And so whilst this looks very nice on paper, and I keep saying this to me is minimum level of service victims should receive, it is not being delivered well, and when it's not delivered well, there's no accountability. And in my role as Victims Commissioner, I have some power, not a lot, but I have some power to hold agencies to account when they are not complying with the code. But I cannot do that if I have no data.
You do have data in the annual victim survey, as you referred to earlier, 2024. So should we have that, please? WITN 0455003, page 6.
I see you smiling at that.
Sorry?
I see you smiling at that, the annual victims survey.
Well, when you say data,
Yes.
it's my office is funding that in order to get some idea of how the code is working. Mm-hmm. So it's it's a frustration, and my office is very small. I came in January, and it's a tiny office with not much budget, and it may not have budget to continue to do the annual victim survey. If my office can't do this, what insight and data will we get about the victim's experience and journey and how the code is actually working in practice?
We see at page 6, key findings. Victims lacked confidence in the fairness and effectiveness of the criminal justice system. Factors undermining confidence include a lack of resources, poor communication between criminal justice agencies and systemic biases. They reported feeling like they were not believed or taken seriously. If we go, please, to page 7. Victims' experience following a charging decision varied greatly. Victim confidence in the effectiveness of the CPS and satisfaction with the quality of communications about charging decisions, the court process and court outcomes was mixed. And we see at the bottom of the page, only around a quarter, 27%, told us they recall being referred or had self-referred to victims' services. For victims whose case reached court, this only increased to 56%. Nearly two-thirds agreed the support they received was tailored to their needs, though some victims emphasised the need for more individualised support, and just over half agreed their contact with victim service helped them to recover from the impacts of crime. And page 8, please. As you said, the 17%, less than a fifth, 17% of respondents had heard of the victim's code. Less than two-thirds of victims recall being offered the opportunity to make a victim personal statement when cases had progressed to court. What was your cohort for the survey?
So again, this was done before I was in the role, but I believe it was over 6,500 victims. We have just, we are doing the survey again, and we have just closed the survey recently.
And as Ms. Call reminds me, you have very clearly at page 55 set out the proportion of respondents who'd heard of the victim's code. Only 17%.
Yeah. So in the Victims and Prisoners Act, there is a duty on agencies to promote the code. Not been implemented yet. That doesn't mean agencies should not be doing it. I don't know what we're waiting for, but we know so few are being told. I mean, I meet victims often at the end of the journey because I'm not allowed to be involved at all in operational decisions, so we tend to meet till they've gone through the process. And it's one of the first questions I ask, were you made aware of the victims' code? And so few are. I mean, the response that I get when I question agencies is they'll say, well, we don't explicitly say it's a code, but we do tell them, we do update them and we do tell them that they're being updated. I mean, there is some disparity because when I was in the London role, I was very robust in trying to look at compliance data, and we could see that actually from the Met data, they had been referring victims to support services, but we could see that there was a mismatch with victims saying, I hadn't been referred to support service. Because again, it's about how is that information being communicated to someone who is in trauma shock, suffering with grief, going through so much, I think there's almost it is a tick box where they'll say, well, I told them about support, might have said it once to them, but they may not have processed that information. So it's not just a case of ticking, I told them, it's updating them all the time and checking in. It shouldn't be a one-off offer. It should be throughout for every agency, everyone who's coming in contact with that victim or family member. Are you aware of the Victims Code? Have you been told about support services? Would you like to access support services? If not, tell us when. You know, make sure the offer is continually made. It should be a service. It's a customer service in a way. That's how I view it. To treat them with dignity and respect and make sure you are listening to them and talking to them and updating them throughout the process.
One of our victims, Sharon Miller, didn't get her property back until January 2026. These are important issues, aren't they?
Yeah. And I think that what's so difficult there, and I go back to the hub idea, it's when things are not working, which often they aren't. So if things are not being information's not being given, you don't understand something, it is so difficult. I mean, bereaved families will have the family liaison officer who should be the person trying to resolve some of those issues. Some of it might go beyond their remit, and that's why with the Victim Care Hub, and that's for other victims, if something hasn't happened, you have somewhere to go that someone will sort the problem for you. Otherwise, so many victims and families are like, where am I meant to go to get the right advice and information? We make it very, very difficult, and we make it very, very challenging for them.
Can we have, please, WITN 0455008, page 1, Victims Commissioner's submission to the Ministry of Justice's consultation on a new Victims Code. And we see set out there in the executive summary at the bottom, the Commissioner welcomes the ambition to strengthen the code. The submission concludes that without systemic reform, robust accountability and genuine cultural change, the revised code risks remaining aspirational rather than transformative. And if we can have pages 2 and 3, please, on the screen. The key criticisms of the code, what do you say about that?
Well, I think it's echoing what I've been talking about around it being, poorly implemented. It feels very much like a tick box exercise for so many agencies, as opposed to really trying to understand the victim position, the victim's needs, and therefore tailoring your responses, your communication, your service to those needs. As I've talked about, the lack of enforcement and accountability, it is the code's greatest weakness, because there is, as I've mentioned, nothing in place to give us robust monitoring and oversight of how the code is actually working. Victims are just forced to advocate for themselves to get their rights, and the fragmentation through the criminal justice system, that is the biggest issue. The victim and the family, victim in particular who's maybe going to court, they have to navigate that entire justice process and post-sentencing as well. And yet there is nobody who can track that victim and support them through the process. Again, another recommendation that I've made to various legislations, and they've not been taken forward, is around that unique victim identifier number. So you identify the victim and their needs, and it is tracked along the process. So they don't have to keep retelling their experience, their story, every time they phone in to the police or when they go into the next part of the criminal justice system. It follows through with them so we can understand, okay, this is their needs, this is what's been delivered, this is what's not been delivered. Let's make sure we are on track for giving them everything they need to support them through the whole journey. And that doesn't happen.
And you see, key recommendations, page 4. Make the code enforceable and accountable, as you've been saying. And how can that be done?
So we actually looked at different mechanisms for the victims and prisoners when it's a victims and prisoners bill about redress mechanisms to make sure that there's some consequence when agencies breach the code. We talked about whether we, shame agencies, whether we look at fines, etc. Again, government was given previous government, quite a number of different solutions for how to drive, to make it enforceable and to make sure agencies were held to account. I think it's one for government to still look at and address because, as I said, it's all very well having the code, but when rights are breached, if you're just receiving an empty apology and there's no accountability and you get no sense what's going to change on the back of that, and that's something I take to agencies. Have you looked at all your complaints that are in relation to your code breaches? They often haven't. Look at your code breaches and what are you doing to extract from that and drive better performance so that you don't keep making the same mistake. That work doesn't happen.
Thank you. Those are my questions, Commissioner. I don't know if this is a good time for the morning break.
Yes, I think we'll take the morning break. So we start again at 5 to 12. Thank you.
Please stand.
Thanks, Mr Maloney.
Ms Waxman, I ask questions on behalf of the bereaved families. You've spoken this morning about your request for mandatory training in the Crown Prosecution Service and the police on the Victims' Code. Can I just ask you about counsel who prosecute cases at court, especially in homicide cases? They're very often members of the independent bar and therefore self-employed, not employed by the Crown Prosecution Service nor the police. In what is reported to you from the experiences of bereaved families in homicide cases, are some more empathetic than others when dealing with bereaved families?
Yes, I mean we do pick up issues of, well, I would say some real concerning issues that come up in court.
Some will be of genuine support and assistance to families, won't they?
Some will, but unfortunately, so in my role, I'll obviously hear the negatives. So when people come and share experiences with me, so what we pick up is just a sort of being quite rushed and not giving information in a clear way and not really listening to victim families at that time.
Perhaps the attitude might be described as compassion fatigue at times. I see
Yes.
you nod, thank you. Now that is capable of being enormously distressing for those families, and especially at such an incredibly important and stressful time that the criminal process is.
Yes.
And you may have heard the evidence of these bereaved families about how they felt at court and how unhappy they were at times. And counsel at court, especially leading counsel, are usually the leaders of the prosecution team that the families encounter, aren't they?
Yes, that's correct.
The counsel becomes the mouthpiece for the team, as it were, in dealing with the families and explaining what's going on at court.
Yes.
Is there any mandatory training in appropriate communication with bereaved families for members of the independent bar who prosecute homicide cases?
I'm afraid I couldn't answer. Not that I'm aware of, but there could well be. But obviously that's a question for the bar. I can only talk about with the sort of the CPS and working with them and understanding what training is available for CPS prosecutors. So I'm not clear what training is available.
If there isn't, in the experience, in your role as the Victims Commissioner and what's reported to you, do you think it would be beneficial?
Absolutely. I mean, there is some work underway at the moment. It's specific for rape cases with the bar, looking at better training and being trauma-informed, that is being led actually by the independent advisor for the government, Catherine Holes. So she's leading on looking at that training in court, but it's specifically only around rape cases.
It is, because there is quite holistic training for prosecuting in rape cases, isn't there? The RASOL system.
Yes.
But you think that training of that nature in relation to homicide might also be useful in terms of dealing with bereaved families at court and victims?
I think it's necessary for everybody who comes into contact with families in the court, even from the court clerks, and we've talked about that as well. Everybody should be trained to understand impact of trauma and the needs of victims and bereaved families in court.
Thank you very much, Ms Waxman.
Yes, let's go and try it. Thank you. So I think just a couple of questions that I have. Just in relation to the hub that you're referring to and the, for want of a better word, interface with the FLOs, the flows. From your experience, would it be better to have, say, one flow on a case, that's to say, a single point of contact for more people coming from the hub side, rather than several flows and independent advocates as well? So that way you effectively have a single point of contact from the investigation team, but a trained flow, keeping contact with the families, but through the hub.
So again, I think it's what works best for victims and families. So are you talking about, so is it, it's not one flow for, say there's numerous victims or families, they'll all have their individual flows still, but you're talking about there'll be one flow out of that cohort will then liaise with the with the hub? Is that
Possibly, or alternatively, just one flow for all victims, but all of the victims have their own representative from the hub instead. So, in a sense, the independent guide is on the other side of the equation.
On the other side, I understand the question. So, again, as I say, this is still a concept, and it's something we really have to map out carefully. And when I talk about mapping out, it's understanding all the intricacies of the journey for victims and families, but it's also plugging in and recognising the needs of families and victims. Anything I would push forward and design has to be centred in consultation with victims and families.
Yes.
So, but I think if it was just to navigate the justice process, it is probably better to have the hub be the point of contact that would communicate, certainly for victims. For families, I'm not sure, because obviously the flow is providing extra things as well that the families need to access that the hub wouldn't necessarily give to the families. So again, it's something that has to be worked on through the design of this.
And the hub, for example, would you envisage somebody who was able to assist in relation to the criminal justice system also being able to assist in relation to, for example, liaison with the health service?
No, so this hub is purely for navigating criminal justice system only and following the rights and entitlements under the code, making sure that they are being delivered as they should be to victims going through that justice process. It could probably provide in the sense of maybe referring them on to whoever they need to be referred on to for support in that area, but it's primarily looking at criminal justice only.
I see. And in terms of the resistance that you've encountered in government to a number of these suggestions and recommendations, what have been the grounds of that resistance, if you can help me?
So, I mean, in relation to the Victim Care Hub, I actually think it's just a lack of ambition and just sticking with the status quo and hoping we can improve the status quo. So let's train the police, let's train the CPS, let's get everyone better at understanding the code entitlements and just make sure they do a better job. We've been trying that for years. It doesn't work. I think we need a complete overhaul in the way that we respond and support victims and families in the criminal justice system. So I think that's just a lack of ambition in relation to the Victim Care Hub, and something I will continue as Victims Commissioner to push government on. The unique victim identifier number, there is more openness to this, and there is work going on within the Ministry of Justice looking at how best to collate some of the data on that victim journey. And so I'm
Is the idea that there are numbers to maintain anonymity or continuity? Because it's slightly concerning just to be a number in a system where
so
you
no,
don't
not
trust
enough.
the system.
Yeah, so we understand that, and that's something we'd have to explore. But at the moment, it's coming from the need of victims who say nobody knows what their needs are, nobody doesn't respond to their needs because they're not tracking those needs and their requirements along the system. So they are having to either retell it again and again to different parts of the system, or nobody asks at all, and therefore they don't get the right response and service. So it's more from ensuring there's a better quality of service provided to them. So it's looking on the system, so it's not necessarily
it could be a code.
You're not a number. It's actually in a way to try and provide a more human response than the system currently does. So it's making sure we know who you are and what you've been asking for and what your needs are. And I'd also like it to be able to track, right, were they referred to support, double check, were you referred to support? So you're tracking the journey under the Victims Code, and they've got everything they should have got throughout the process.
Yes, and just in relation to the difficulties that you have as the Commissioner in monitoring because you don't have any data, what would be the best way, do you consider, to collect data?
So I think that unique victim identifier number could be a solution to helping us understand that victim journey in relation to the code compliance and what agencies are and aren't giving to victims through the process. I know
who would keep that record? All agencies, and then you would
very
have
good
to do
question.
the work.
Very good question. I don't think I'd have the answer to that. That's some, as I said, that the Ministry of Justice are looking at all of the data requirements regarding victims' journey at the moment. I know there are big issues with it because all this data sits across different systems. And there's not one system, as you know, so everybody, it's the lack of communication, and they're just not interacting with each other. So that's a big issue around accessing this data and getting this data, and where it sits and who has ownership of it. So the idea was that the police and crime commissioners would play quite an active role, and the framework would be built around them actually being able to get this data from different agencies. Of course, with the police reform and the abolition of PCCs, that's kind of put a spanner in the works, and we don't know what's going to happen now as a result. So unfortunately, the progress that we made through the Victims and Prisoners Act to try and access this data from agencies, or to start to put the framework together, is pretty much paused. So that makes my job very, very difficult in monitoring and having some oversight about how the code is actually working in practice.
Yes, thank you. And I think that it's right that in most cases we effectively have the 2 pages of the victims' rights, that flows do give those in most cases to the victims, but it's a question really of whether they are explained, whether they are understood, whether it's the right time.
I mean, I don't know if I'm confident that they do give it.
I see.
It's a question I will ask bereaved families. I don't know if they do get everything as they should, so information about their
because
code
it's
rights.
a very simple.
It is very simple.
2-side of A4, isn't it?
But again, I think we need to really think about what families, in particular bereaved families, are going through at that time. I speak to bereaved families, they get leaflets after leaflets and booklets, and what we just leave it on the side and we expect them to read it all, to be able to process it and retain that information at a time when they are really struggling with grief and trauma and shock. There is no way they can process all these big booklets and information. So it's about providing a much more tailored service to help them understand what they need, what their rights are, in a sensitive, gentle way that helps support them through the process. Yeah. I don't think that's too much to ask for.
No, thank you very much. Well, thank you. That's the end of your evidence. So if you'd like to go with the usher. Thank you. So, after 14 weeks and 164 witnesses, we've reached the conclusion of the oral evidence hearings in this inquiry. Over the course of the hearings, all witnesses attended when they were asked to do so, apart from one occasion, and it's been unnecessary to reschedule any witnesses or depart from the timetable, and that occasion was for illness. Further witness evidence has been uploaded onto the website, as you've heard this morning, and a few outstanding statements addressing issues which have arisen from the evidence which has been given will be disclosed to CPs and, where appropriate, published on the website. The fact that we've completed the evidence on schedule without compromise as to breadth and depth is a credit to all core participants and their representatives, and of course to counsel to the inquiry legal team and the secretariat who've organised the hearings. In addition to the evidence which had previously been considered in other reports, the inquiry has obtained and presented evidence which has not previously been taken into account in those reports or proceedings. And I'm now going to start work on my report, considering the evidence ahead of a further hearing at Mary Ward House on the 8th and 9th of September for oral closing submissions. Counsel for core participants have been sent a timetable which I've set for the September hearing, and I'm just going to briefly summarise that. All written closing submissions on behalf of core participants who wish to make submissions shall be provided to the inquiry by 4 o'clock on Friday the 14th of August. And after reviewing the submissions, if there are any particular issues on which I require particular submissions, I will notify relevant counsel by the 28th of August, and such submissions shall be provided by the 4th of September. So if you receive no notice from me after submitting your submissions, then no further submissions will be required from you in advance of the hearing. And the oral submissions will be live streamed, and you should be aware that the technology that we've had the benefit of to upload documents and primary evidence on screen will not be available at the hearing room on the 8th and 9th of September. So accurate references to documents are both essential and sufficient. And on the subject of broadcasting, I remind everyone that the broadcasting order of the 11th of November remains in force and prohibits any rebroadcasting of video or audio clips from the live stream unless such broadcasting is or constitutes a fair and accurate report of proceedings. Now, before we finish today, on behalf of us all, I would like to thank all at Mary Ward House, the ushers, the security and Hestia, for their contribution to making the hearings in this emotional and taxing inquiry as comfortable and bearable as possible for all concerned. We've been fortunate indeed to have had the spacious calm of this historic building and the professionalism, kindness and thoughtful assistance of all in it. Further thanks are due to RTS for the smooth running of the document system, to our document controllers and stenographer, and to my clerk Eileen for her unfailing support. So that concludes this part of the inquiry, which I now adjourn till the 8th of September.